Namaste students. Today's topic, relevancy of opinion, section 45 to 51 of the Indian Evidence Act 1872. The questions, kindly take down the questions. It is in this manner. Who is an expert? I repeat, who is an expert? Explain the matters in relation to which the opinion of experts become relevant. Or one more question. Who is an expert? When does his opinion becomes relevant? So what you have to write? What will be your answer of 4 pages or 4.5 pages of answer? Let us understand the word opinion. You know, God has given a wonderful object, a part, an organ in our human body. That is the brain, the softest organ, a ball of soft muscles with thousands and thousands of nervous system, micro nervous system connecting, mastering the entire body. We may sleep, we may be awake, but the brain always thinks, calculates. The brain calculates on anything and everything on this earth. It draws inferences. It will have its own meaning for the happenings. And you know, it will give a result on a particular thing, on a particular person, on a particular incident, on a particular matter. That view of the brain is called opinion. You know, when you read a book, any book, after reading the book your mind says, it's a bad book. That is the opinion. You go to a hotel and you eat some food, and afterwards your mind says, wonderful food. That is your opinion. When you look at a movie, you may appreciate it. That is your opinion. So, the inferences, drawing the inferences of mind on various subjects is called opinion. It is the views of the brain. Now the question here is, relevancy means importance of this word opinion before the court of law. Is it relevant or is it irrelevant? There is a general rule. What is the general rule? Court is an institution established to decide the disputes, the problems of the parties on the basis of evidences, on the basis of true evidences, oral evidence or documentary evidences. Fact has to be presented and nothing else has to be presented. So, opinion about something differs from one person to another, another to some another. Hence, opinion do not have any value in the eye of law before the trial in the court. So general rule is, opinion is not relevant. You know, in Stephen's digest on evidence, he gives 2 examples. One is the example of a painter. A painter is called to the trial of a murder case, and he will be made to stand in the witness box, and he will be told, explain your opinion about this murder. That painter will give his own analysis. Now the question is, it is only an analysis. It is not the relevant fact. In the same sense, a writer or a poet, or a dramatist, if they are called to the court of law to give their opinion, they are going to give their opinion in their own manner, which is definitely accepted, going to mislead the mind of the judges. That's why opinion is not relevant before the court. This is the general rule. Very easy, right? Now the question is, then why there is section 45 to 51 Evidence Act explains about the so-called simple opinion. Here says, there is an exception. Exception means, in our country there are experts on every field, and these experts, they are the masters. They can give their opinion on certain subjects. Now what are the subjects? Subject of science, art, architecture, weaponology, fingerprints, blood analysis, analysis on the dead body, forensic science. So many things are there on this earth where there are experts to give their opinion. So the law says, on this matter, the court is having the freedom to invite an expert and to take his opinion, because the judge who sits there to decide the case is an ordinary person with the basic law degree education and little experience. He is not a forensic expert. He is not a scientific expert. He is not an expert in the traffic analysis. So, he has to be assisted by an expert. Right? So, now let us understand. I will give you some 5 cases here. What is the meaning of an expert? Let us analyze one by one. First case, Kishan Singh versus State of Punjab, 1953. I think all of you are lucky that you have all the 5 senses with you. Eyes, ears, nose, tongue, touch, right? Now there are people who do not have the support of these 5 senses. What you can call them as? Deaf and dumb, deaf and blind, right? Yes. So, this case is connected to a criminal, an accused who is acting like a dumb personality. That means, so what happened? Criminal case has been filed against him and he cannot answer. So the judge was requested by the police, Your Honor, he is a dramatist, he is acting like a dumb person, please subject him to examination. And the judge was very intelligent. I think you have studied in normal schools and colleges. And here the judge found out one governmental deaf, dumb, blind school headmaster. Headmaster was invited to the court and this accused was delivered to his custody so that he can conduct the tests and to give the report whether he is acting or whether he is genuinely a dumb person. Headmaster very sincerely analyzed this person and gave a report that this man do not have any defects. He is a normal human being. He is only pretending to be a dumb personality. So here the court said, it was challenged in the Supreme Court. Here the Supreme Court says, the headmaster of a deaf, dumb, blind school is an expert. He can give his opinion and the opinion is relevant. Okay? Yes. Let us take one more beautiful case. Abdul Rahman versus State of Mysore, 1972. I think all of you know jewels. There are duplicate jewels. There are original jewels. There are duplicate diamonds, original diamonds. You and me, we are ordinary persons. We do not know anything about the original and the duplicate. For us, everything that glitters is gold. But for an expert, everything that glitters cannot be a gold. Right? So what happened? You know, in the banks, there are safe deposit lockers. The elite class of people bring the valuables and keep it in the bank. And you know, whenever they want, they used to come and take it away. So there was one such safe deposit lockers with the original jewels. And there was a man serving in the bank. Very, very clever personality. He took out all the originals, got it prepared, duplicate jewels, which appears to be original, and replaced it there in that locker and kept quiet. But when the original owner came and inspected the jewels, he doubted and he filed a case against the bank and the other staff. And you know, there the question is, we are sincere, we are honest, we have not committed any crime, we have not done any such things. But the proof has to be analyzed, and the court called upon, you know, jewelry shop owners here and there. There are so many jewelry shop owners. One such illiterate, old, experienced jewelry shop owner was called, and he was handed all the jewels for his analysis. He conducted certain tests on that. See, these illiterates, they conducted. And afterwards, he gave a report. They are not gold. They are duplicate jewels. So here, just for our analysis, you have to write in the exam. In this case, Abdul Rahman's case, the Supreme Court held that an illiterate goldsmith, an illiterate jewelry shop owner is considered as an expert in the field of metallurgy. One more example, one more case. R versus Oakley, 1979. Accident takes place. Will there be witnesses for all the accidents in our society? Sometimes there are witnesses who can tell whether this vehicle owner is wrong or this vehicle owner is wrong, who is careless, they can say. There are certain witnesses, onlookers, if they're ready to help, yes, that they can be accepted. But in certain cases, the accident take place in the absence of any witnesses. Then the question comes, who is the culprit? Who is the careless driver? So responsibility has to be fixed. So in this Oakley case, one such accident took place and the court ordered, bring the best traffic police constable who served and retired. Call him. So traffic inspector was deputed and he came. Sincerely he analyzed the spot and then he gave a report that this owner is the negligent driver. He is responsible for this accident. The court accepted the opinion of a retired traffic police constable. So he is an expert. One more case. Baldev Raj versus Urmila Kumari, 1979. Today, the marriage took place. Consider today. The marriage took place. That new husband and wife, husband started doubting the lady. Within 20 days, he complained to his father about the character of the lady. And the husband's family compelled, come with us to the doctor. We'll go to the hospital. We have to conduct examination on your body. The lady, in this new period of marriage with dreams, she was compelled. She was taken to the doctor. In the hospital, there was an MBBS doctor. So all the family members insisted. And the doctor conducted the medical examination on the lady. And she gave a report that this patient is having 2.5 months of pregnancy. The lady and her parents, they dispute the claim of pregnancy. And the matter came before the Supreme Court of India. What is the question here? An MBBS doctor, the girl side says, no, he is not an expert. He is not qualified. That doctor do not have any knowledge about the diseases of the females. So that report has to be rejected. Later, the Supreme Court has to find out the meaning of this word, MBBS, an expert. Can an MBBS doctor be called as an expert in respect of pregnancy, gynecology? You may not believe, the villages of India, the judges took the examples of villages of our country. In every village in those olden days, you used to find an illiterate old woman. In short, we can call her as country nurse, country nurse. So, when an illiterate lady in a village can analyze the body of a lady and to tell whether she is pregnant or not. That illiterate country nurse is considered as an expert in our country from the past hundreds of years. And today, can't we consider an MBBS graduate doctor as an expert to analyze whether the lady is a pregnant lady or not? Supreme Court held an MBBS doctor is an expert, is having sufficient knowledge to analyze a lady as pregnant or not. They have accepted this judgment, and then they are helpful in securing the divorce in this case. Okay? And it was proved that she had some affair earlier, and she was pregnant earlier, about at least 2 months before her marriage. Okay? So our analysis is only this much. An MBBS doctor is also called an expert. That's enough. Now go to the last case, R versus Smith, 1979. All of you know Shakespeare, the wonderful dramatist of United Kingdom and the world-class writer. He has written a book called Macbeth. And in that Macbeth, there is a story of sleepwalk. In the night, a man, the king, will get up from the bed, wholesale candlelight, and moves in the dark without his consciousness. That means he is in the subconscious level and he do not know what he is doing. Sleepwalking. It is an illness of mind. So here is a case connected to this problem. There was a husband and wife. Husband was not liking the wife. He wants to get rid of the lady by one way or the other way. And he started one day getting up in the middle of the night and moving around. This continued for many weeks, many months. See, the criminals make always the plan. They are the planners. They are the conspirators. So, he made plan, very successful plan. He used to walk holding a knife. He used to walk in the night holding a knife. One day, while he was walking, he just pierced the knife into the stomach of the wife. As a result, she suffered death. And the trial commenced. His advocates, the defense advocates, requested the court, Your Honor, our client is suffering from unsoundness of mind. He is having the illness of sleepwalking. It is called automatism. So, when the matter comes before the court, they are requesting for acquittal, saying he is suffering from this disease. It is an exception. Fine. Judges cannot accept all the defenses presented before the court. And the judge ordered, very good. Oh, your client is suffering from disease, that's fine. But the judge called upon the expert psychiatrists and delivered that person to their control, requesting them to give the report within the specified time. I think nowadays, all of you know this, truth serum. Truth serum. You know, it's a liquid. If it is injected into your body, you lose control of your brain. Howsoever strong you may be, you will be compelled to give the true answers from your mouth. So here the court, the experts said, they conducted various tests and they said, this man is not having any mental illness. He is having a sound mind, a strong mind. He has made the story to protect himself. So the court said, we accept the evidence of, opinion of psychiatrists, and on the basis of this, he was given the conviction. Okay? So, I am giving you minimum 5 cases. It's enough. You know, you can write in the exam. Remember, all of you, a judge is called a generalist. He is not an expert. He may be knowing 40, 50 laws of our country. He do not know all the laws of our country. In the same sense, he do not know medicine, he do not know forensic science, he do not know finger experts, technology, art, so many things. So, write this much about the relevancy of opinion of experts. Thank you for today.